Hello, my name is Cliff Marchek. I'm the Community Service Director at the William S. Boyd School of Law. Welcome to another section of our ongoing series of community service classes. This class is entitled Divorce Without Children. In the state of Nevada, there are two methods to get a divorce, and there are 4 issues in a divorce, generally speaking. This section I'm going to talk about how to get a divorce without minor children. There will be another class on how to divorce with children. I will cover the issues involved in a divorce and the methods to obtain a divorce. With any divorce case, there are, in this class, 3 major issues. 1, to end the marriage. 2, division of community property, and 3, alimony. Nevada is a no-fault divorce state. One party simply has to assert that he or she is incompatible with the other parent, and you get a divorce. The other parent or spouse cannot block one parent from getting a divorce by alleging that you are compatible. Simply put, if one person wants a divorce, he or she will get it. The second issue is division of community property. Now, community property includes assets and debts. The general rule of community property is any property acquired or any debt incurred during the marriage is community and must be divided 50-50. You notice I didn't say any property acquired or any debt incurred in both names. Community property law is generally a time rule, not a title rule. Therefore, if it's something that's acquired or it's a debt that's incurred during the marriage, the presumption is it's community and must be divided 50-50. There are 3 exceptions to that rule. 1, if property is acquired by one spouse as a gift during the marriage, that will remain that spouse's property. Number 2, if someone receives property through an inheritance, either through a will or by what's called intestate succession, that property will remain that spouse's sole and separate property. The third exception to the rule is if anyone is injured and receives a settlement or a verdict in a case for personal injuries, that also is separate property. Any property acquired before the marriage is generally separate property also. However, I will caution you that if something was purchased before marriage and payments were made on that property after marriage, it could be part community and part separate. If you have anything like that, and what I'm principally talking about are homes and cars. You'll want to talk to an attorney to determine what portion of that is community versus separate, whether or not it's all community or whether it's actually been transmuted into all separate. Community property must be divided. Now, community property includes assets and debts. It includes traditional things like homes, cars, personal possessions such as household furnishings, electronics. It includes retirement plans such as 401ks. It also includes pension plans even if nobody is near retirement. If one spouse has contributed to a pension, such as a military pension, federal employees pension, or private pension plan through what's called ERISA, or maybe through a public employees retirement plan, that non-contributing spouse has a community property interest in that spouse's retirement, and you must consult an attorney if that situation exists. The way that community property interest is recognized for the non-contributing spouse is through what's called a qualified domestic relations order. Businesses, if one person runs a business or if both parties run a business, that is a community property asset if it was used, was an ongoing business during the marriage. Obviously, debts are part of property. Credit card debts, loans on homes, loans on vehicles, judgments against one or both spouses potentially. So a lot of things go into community property. Before you go to court, it's a good idea to discuss how to distribute the community property with your spouse before going to court and having a judge decide it. The UNLV Boyd School of Law actually has an asset debt mediation program that you can access once you're filed your complaint and answer. And it's a program that's free of charge to the public, and you can go there and have a trained mediator who will assist you in trying to resolve the asset debt distribution. Remember a couple things about community property. Generally speaking, the person who gets the asset should get the debt. For example, if someone's going to receive the 2006 Honda Accord, but there is a loan on that car, generally speaking, the person who gets the Honda Accord will probably get the loan. Also, when you come to an end on each ledger, they should be about equal. So when you're give the assets and debts to the husband a certain allocation, same to the wife, they should be roughly equal. If you wish to do a disequal distribution, you want to consult an attorney. So that's the second issue of a divorce. The third issue is alimony. Alimony is something that one spouse can receive from the other if certain factors exist, and there are several factors. One, the court will look at the length of marriage. Generally, marriages of short-term duration, that is under 7 years, are probably not, under most circumstances, cases that will draw an alimony award, but there's always exceptions. So you got to have somewhere between 7 to 10 year marriage to sort of be in the ballpark, generally speaking, to have possible alimony awards. Second, there has to be a disparity or a difference in income between spouses. Third, there has to be a disparity or an unequal ability to earn in the future. Fourth, the court will look at who raised the children, if there were children, and generally what they're looking at is who sacrificed one's career for the marriage. They'll look at education or skills that were acquired during the marriage by, say, the higher earning spouse. And then they will look at maybe some additional factors, but those are the primary factors, and come to a decision. Now, some alimony awards can be for rehabilitative alimony, that is to give the lesser earning spouse a lump sum to put him or her on equal footing in the marketplace, or closer to equal footing with the higher earning spouse. Alimony can be for a period of time. Not all alimony awards are until death or remarriage. Some alimony awards will be for, say, a third or a half length of the marriage. It depends on how long the marriage is and the need. So there's a lot of factors that go into considering alimony. If you believe you are entitled or you may be required to pay alimony, we highly suggest you consult an attorney about the individual facts and circumstances in your case. So those are the issues that we're going to discuss in this section. Remember, we have another section we'll tape later with children. Now, there are two ways. One is by joint petition, which is by agreement. What this means is that both parties must agree on all of the issues. Must agree to get a divorce, must agree to divide the community property, must agree on whether or not there will be alimony, and if there is, how much and for how long. You can only do a joint petition if you agree on all issues. If you do, then both parents can go to the self-help center. Remember, the self-help center is at the family court building at 601 North Pecos, or go online to the self-help center and acquire the forms or purchase the forms for a joint petition. You'll be required to fill out a document called a joint petition, where you will specify who gets what with respect to the issues I've recently mentioned. Both parties will sign it, must be notarized. The Self-Help Center has notaries. They're $2 per signature. Once the joint petition has been filled out, you must file the joint petition with the court. And when you file that joint petition, you'll get a case number and a department. The filing of the joint petition itself does not result in a divorce. You must file additional papers after that to get your decree of divorce. But once you file the joint petition, you'll get a case number and a department. Then you must take your decree, fill it out, and have it mirror the substantive or the important parts of the joint petition. That is, who's going to get what property and debt, whether or not there's going to be alimony. Women can also have their maiden name restored if they like. You will put that also in the decree, and then you will submit a packet to the judge, or you can do a prove-up hearing to get divorced. Now, we have previously have a segment on videotape of a prove-up hearing, so I'm not going to cover that here. But the other method is what's called a request for summary disposition. The Self-Help Center has these forms, and the request for summary disposition is simply submitting papers without actually having to appear in a courtroom to get divorced. There is a document called a request for summary disposition. You'll need to have an affidavit attached to that from one of the co-petitioners. There will be an affidavit signed from a resident witness. This is simply a person who can attest that one of the parties is a resident of the state of Nevada, and to get a divorce in Nevada, one party has to have lived here for at least 6 weeks. The additional document will be the welfare party sheet, and then you're going to submit, and a courtesy copy of the joint petition. You're going to submit this packet to the judge you were assigned when you filed the joint petition. At the family court at 601 North Pecos, all judges' chambers are on the 3rd floor of the family court building. You will drop this packet into the judges' chambers on the 3rd floor of the court building. If everything is filled out correctly, within a week to 2 weeks, you'll be notified that your decree's been signed and it's available to pick up. If by chance you've not filled something out correctly, you will be notified of that also, and there will be a sheet that's attached to your packet indicating what was not done correctly. If it's something that can be fixed, simply make the correction and resubmit it. Then once it's done correctly, the judge will sign it. You'll get your decree of divorce. The last thing you must do is mail the notice of entry of decree to the other party, and you have gotten divorced. You never appeared in a courtroom. It's the least expensive, probably the least traumatic, I'll say, for a lack of a better word, but you have to come to an agreement on all terms. The other type of divorce is if you cannot come to an agreement, or if you simply can't locate your spouse. It's called the complaint and answer process. And a complaint is a document one party files, which is essentially a wish list. It's something where you allege facts and circumstances relating to the marriage and what you want out of the marriage. And in this case, we're talking principally about division of property and alimony. So you would make allegations in there of what property and debts you want, what property and debts the other party should get, and the same for alimony. If you're requesting it, you want to make sure you put it in there and at least give some number that you might want, or consult with an attorney before you actually plug a number in there of how much you want per month. But you need to make the request in the complaint if you want alimony. Then you must file the complaint. Now, the filing fee for a complaint is $289. If you cannot afford that, you can get a fee waiver at the Self-Help Center. You file the complaint. Other documents that you must file with a complaint are a summons and an optional document called a joint preliminary injunction. The summons is something that needs to be served with the complaint after you file it. And we have a whole class, a whole segment on these videotapes that discuss service, and I will turn you to that video so you can see how service is effectuated. The joint preliminary injunction does 3 nice things, and it applies to both parties, and you can have it served with the summons and complaint. It issues an anti-stalking or a restraining order. It issues an order that neither party should waste away community property or further encumber unnecessarily community debt. And it issues an order on both parties that neither party should remove the minor children from the state with the intent to deprive the court of jurisdiction. So you file these documents, then you must serve them. Once the defendant's served, the defendant has 20 days to answer the complaint. Now, a few things can happen here. The defendant may not answer. If the defendant does not file an answer within 20 days, and by the way, answers simply get filed with the court and mailed to the plaintiff at the address provided on the complaint. You do not need to personally serve the answer onto the plaintiff like the plaintiff had to personally serve the complaint onto the defendant. Once the answer, if the defendant does not answer the complaint, then the plaintiff must go down and enter the default, and he or she can do that on the 21st day. If she enters the default, then she must submit papers to the court to get divorced. She's not divorced yet. She's kind of chopping her way through the system. She must now go down and submit the decree with an affidavit of resident witness, with a courtesy copy of the complaint to the judge, and she can do that in a fashion very similar to what I described in the joint petition section where we talked about a request for summary disposition. Or she can set it for a prove-up hearing and get divorced that way. If the defendant answers and disagrees with anything in the complaint, now you're in a contested divorce. Several things will occur. First, the court will notice a case management conference and the parties are required to attend. This case management conference is an opportunity for the judge to meet the parties and to get an idea what issues are in dispute. Based on that conference, the judge will set all appropriate dates, including a discovery date and a trial date if necessary. Second, if there is anything in dispute, discovery occurs at this point. And if one party has not been forthcoming or one party believes the other party's not been forthcoming, you can request information from the other party. You can send out what are called interrogatories, which are questions to the other party. You can submit a document called a request for production of documents, which asks the other party to produce documents. You can take the deposition of the other party, which is questioning the other party under oath, just as if you're in a court of law. And you can also subpoena records from third parties. Discovery is a very important part of the litigation process because it enables the parties to acquire all information necessary to go to trial. Once discovery is done, and if the parties couldn't resolve the assets and debts and alimony issue through the mediation program or some other mediation, the matter will then go to trial. Now, trial is a very complicated process. Something that you will need at the very least is advice from an attorney, preferably representation, because there are many rules of evidence that apply to trial. And you must bring in your witnesses generally, and you must bring in what are called properly authenticated documents to that trial. So if you're unable to settle your case, then you go to trial. If during the litigation you come to a settlement, you don't go to trial. Once the parties have settled matters, you either do a request for summary disposition, which again is submitting papers to the judge, and the judge will sign the decree, or you schedule a prove-up hearing and you go before the court. Divorce is a complicated process. All of you should seek at least legal advice at some point, preferably legal representation before you file, before you make any major decisions, and most certainly before you go to trial. We wish you the best of luck in this process. Thank you for listening.